Dr. Babasaheb Ambedkar Open University.
Hello, my dear friends and students. Welcome to Dr. Babasaheb Ambedkar Open University, Ahmedabad, in Chaitanya Studio of Dr. Babasaheb Ambedkar Open University, Ahmedabad. Today, we gather for the video lecture series in the course of Post-Graduation Diploma in Human Resources in the subject Industrial Relations and Labor Laws, Block 4, Unit 1. Now, before we start our session, let's discuss what are that learning objectives are there. So these are the learning objectives, my dear friends. First, that the impact of I.L.O on the labor laws in India. Then, how to evaluate the principle of labor legislations in India. Then define the role of labor administration in India, then outline the involvement of central and state labor ministry. Then explain the labor statistics and intelligence. Then identify the price index numbers. Now let's start our session with defining the introduction of this particular unit. That the labor movement has contributed a lot for the enactment of law protecting the labor rights in the 19th and 20th century. The history of labor legislation in India can be traced back to the history of British colonialism. The influences of British political economy were naturally dominant in sketching some of these early laws. In the beginning, it was difficult to get enough regular Indian workers to run a British establishment, and hence the law for characterizing the worker became necessary. This was obviously done in order to protect the interest of British employers only. However, today in India, the labor laws are so numerous, complex and ambiguous as they promote the litigation rather than the resolution of problem relating industrial relations. The British enactment and the Factory Act with the self-centered motive, and it is well known that the Indian textile goods offered serious competition to the British textile in export market. In order to make India labor costlier, the Factories Act was the first introduced in 1883. Because of the pressure brought on the British Parliament by the textile moguls of the Manchester, and thus we received the first stipulation of 8 hours of work, the abolition of child labor and restrictions of women in night employment, and the introduction of overtime wages for work beyond 8 hours. While the impact of these measures was clearly for the welfare of labor force, the real motivation was undoubtedly the protection their vested interests. Thus, my dear friends, it's required and legislations for the labor also. Then India provides the core labor standards of I.L.O, that is Indian Labour Organization. For standard for the I.L.O, that is the International Labour Organization, for the welfare of workers and to protect their interest. And India has a number of labor laws addressing various issues such as resolution of industrial dispute, working condition, labor compensation, insurance, child labor, equal remuneration, etc. These are the hurdles of that. And the labor is a subject in a concurrent list of the Indian Constitution. So there are mainly three lists over there in the Indian Constitution. There is a central list, state list, and concurrent list. The concurrent list will deal with these two also, that is a central as well as defining the state also. And is therefore a subject matter in the jurisdiction of both, that is a central as well as state. So we can say the concurrent list. Both central and state government have enacted the law of labor issues, and the central laws grant a power to officers under the central government in some cases and can do the same for the officers of the state government also in some cases. And thus we can evaluate that what are that impact of I.L.O on the standard of labor laws. In India has and only the ratified the four of the core I.L.O labor conventions. In view of a serious problem of a child labor and forced labor, as well as restrictions on the trade union right of worker in EPZs, the continuing the gender discrimination in employment, then determine the measures are needed to comply with the commitments. India accepted the WTO ministerial declaration held in 1996 to 2001 at Singapore, Geneva, Doha, and in I.L.O Declaration of Fundamental Principle and Right at Work adopted in June 1998. So these are the conventions, but the India has not adopted that in an appropriate manner. Or we can say that the legislations are very scrutinized and the litigations are important, but the resolution is not. For that, my dear friends, India has ratified neither the two core I.L.O conventions protecting the trade union rights. While the trade union rights are generally respected to workers in a formal employment, and the vast majority of India's workforce are not in a formal employment and so are not covered by the legal provisions. This is the case for the more than 90% Indian workers. The workers in the export processing zone and excise their relation, or we can say the union right. And India has ratified both the core I.L.O convention on the discrimination also. Then we can say the domestic laws to prohibit discrimination have not managed to curtail the widespread discrimination on various grounds, including gender, caste, and ethnicity. As concerned on the gender discrimination in employment, the participation of women in labor market is we can say the fraction of the male participation rate, and the women's are the further under the representation of the senior position. And India has not ratified either of the two core I.L.O conventions on the child labor, and the child labor is a serious and widespread the problem, not in India but we can say in the world also. And India has ratified both the core I.L.O convention on the forced labor. However, the forced labor is widespread the occurrence also. Then Let's move to the another discussion, that internationally recognized core labor standard in India. My dear friends, you know that this four aspects is important for the any business unit. That is a land, labor, capital, and entrepreneur. And in that, the second point, that is a labor is important. And for that, my dear friend, the government has to take a certain steps for protecting that the right and the interest of the labor. And for that, the internationally recognized the core labor standard approved in India. So approximately 50% of the formal workforce is unionized. And although the formal workforce in India is, we can say, the drafted by the those workers who have no legal recognition of their employment and who perform a range of informal and unprotected work. As you learn in a previous session or in previous units, that these are the also the important for the informal and unprotected work and formal and informal work. So according to that, my dear friends, it has some exorbity and the international recognized core labor standard which are available in India. So the freedom of association, the first point is freedom of association and the right to collective bargaining. The right to the freedom of association in a trade union is guaranteed in the Constitution under Article 19. And the Trade Union Act 1926 prohibit the discrimination against the union member and organizer in formal and informal sectors without any differences. However, as discussed below, the union membership is an informal sector is rare. And in general, the trade union rights are respected in the formal sector in India, and employers may be penalized if they discriminate against the employees engaged in the union activities. And we can say that in the both, we can say the public also and the private sector also, the trade union often exercise the right to strike, and employers are prohibited from taking action against the employees involved, what my dear friends, in a legal strike action. Then collective bargaining. Second aspect is, my dear friend, collective bargaining. The collective bargaining in the normal means of setting wages and settling the dispute in unorganized plan, or or we can say the in organized industrial sector also. That the many important collective agreements expired in 1998, and the unions were put under considerable pressure by the authorities to sign 10 years agreement rather than the traditional 5-year agreements. It is increasing that 5 to 10 years. Although a system of specialized labor courts adjudicate the labor disputes, and there are a long delay and the backlogs of the unresolved cases, the legislation restricting the trade union rights has been passed by the upper house of the parliament. And if ratified, this legislation will increase the workers to 100 or 10% of the workers, whichever is less. The minimum membership for the trade union to be registered over there. Then the recognition of registered trade union is regulated by the code of discipline, which is only voluntarily and is often breached by the employers. And then the planned amendment to the Industrial Dispute Act would permit the firms employing less than 1,000 people to lay off a worker or close down altogether without any consultation of the workforce. And this threshold of 1,000 workers would mean that three quarters of the formal workforce would be stripped of its right to consultation and would essentially be stripped of any jobs securities. And the government is also planning to amend the Contract Labor Act to facilitate outsourcing and contract employment, under which the arrangements workers are receive less legal protection. Then the law on a trade union does not apply in a Sikkim, because you know that there is the constitutional amendments are there. A state annexed to India since 1975, and as a result worker in a Sikkim are not able to exercise the union rights. There are some workers organization, but their coverage is minimal. And the government notice regarding the freedom of association, replacing the law on trade unions in Sikkim, provides for excessive interference by the police and by the public in application of registration of the workers organization. This is a very serious question and serious concern about that the labor standards in India. In a clear violation of the government of the WTO to adhere to the I.L.O's core labor standards, the government of Western Bengal state declared in December 2000 that the trade union activism would no longer be allowed in order to attract industries. And there are the three export processing zones, that is EPZs, and the four special economic zones in India. In theory, the all labor and factory legislation apply fully in the zone, and the workers in the zones have the right to organize and bargain collectively. The government has expressed an assurance at the Indian Labour Conference and Standing the Labour Committee that it will protect worker and trade unions' rights in these zones also, that is the EPZs and SEZs. However, in the practice that the trade unions are the rare despite the efforts of the trade unions organizations work there. The EPZs are surrounded by the security gates, and entry into the EPZs is ordinarily limited to the employees who are bussed directly to and from the factory doors, and meaning that union organizations are not allowed to access that. So after that, dealing with the second important point of the internationally recognized core labor standard in India, that is discrimination and equal remuneration. The low portion of women workers in the total workforce, as well as relative to the female population as a whole, provides an indication to extend that the prejudice. And fast growing urbanization has not resulted in the major increase in a female participation rate. As of the 1990s, of the major cities, women made up just 11% of formal sector workforce in Mumbai, then 8.4% in Chennai, and 7.4% in Delhi, 3.7% in Calcutta. However, The former label statistics vastly undercount the number of women who are working, and their works is often invisible. And it has been the working as a cultivator, agriculture laborer, forest product, or we can say that the product forest produce collector in a tea plantation, construction industries as the land and less laborers, fishers, then the animal husbandries, etc., and tobacco, or we can say the BD worker, and the home based occupation as a weaver and spinner, and the garments, and the food processing and the food processing area as a vendor, and as a worker, or we can say the hawker in the domestic workers. So these are the areas where the women are complaining with as a taking as a formal sector, or we can say the in a laborer also. In fact, that the women constitute only a small majority of a formal workforce is an indication of the level of discrimination in a labor market and a lack of opportunity to enter the formal market. However, at the same time, my dear friends, there are the growing number of families surviving solely of the woman's earnings, and discrimination against the widow is a particularly the pervasive problem. And the women, especially those in informal occupation, are also subject to the sexual harassment also. And for that, my dear friend, the different legislations are over there by the time enforced. And after taking this note, this international recognized core labor standard in India, we can say that despite to the existence of Equal Remuneration Act 1976, which several Indian trade unions organization maintain has not been implemented. Virtually now there are equal wage paid to the man and woman for the same work, as it common of course not in just India but throughout the world also. And some estimates have found that women workers generally earns about 50% of their male colleagues in both urban as well as the rural areas. And although the other sources have contested these figures, and compounding the problem is the fact that women are working in an occupation where the social security legislation does not cover them. As a self-employed or a piece rate worker, it is not equated that the protection of women is not adopted. Whether their work is often the seasonal or casual, such as we can say the self-employed basis, or we can say the piece rate workers in substantial agriculture as a seasonal and a casual worker. However, some innovative schemes are being developed by some self-employed worker organization to cover their members for social security, for providing a social togetherness, social security, adherence. And there are some reports improvement in that situations also. So while, my dear friends, we adopting that international recognized core labor standards in India, at that point of time we have to look at into the our major problem also, and to that evaluate it in that manner which is mainly prescribed, and to provide and protecting the rights and interest of the laborer, whether it is in an informal sector or whether it is in a formal sector. The equal remunerations are also provided. There is no discrimination of that man and woman or genderization, which is not available on that manner. So this is what, my dear friend, that we look at into that. These are the important aspects, my dear friends, where we talked about the I.L.O standards in India, the labor force standard in India. There are the different legislations over there. So this is what important in nature, my dear friends. So in this unit, you have to look it into the basic introduction, origin, meaning, the legislation, different legislations for the labor, also for the industrial disputes, also for the factory, also for the remuneration, also for the wage rate. Also there are different labor laws. If there is a dispute between the employer and employer, employee and employee, employer and employee, at that point of time you have to go to that particular legislations, and which are available for labor also, for the employer also, for the employee also. So this is what, my dear friend, the internationally recognized core standards which is prescribed in India. After view this video, watch this video, you have to evaluate yourself in three aspects, such as long question, short question and MCQ. And then if you want to read something extra, at that point of time, my dear friends, you refer the different books over there. The first aspects of today's session is you have to evaluate yourself by writing this long question. The first long question is, my dear friends, write a detailed note on the impact of I.L.O on the standard of labor laws. Then discuss origin of labor laws in India. After that, in the short question, define what is labor. Then define internationally recognized core labor standard in India. Here we discuss only the two standards. Another standards are also there. So here just you define the two standards over there. Then in a multiple choice question, the Trade Union Act of dash the prohibit the discrimination against union member and organizer in the formal and informal sectors without distinctions. In which year? That is 1921. Then the second question is, recognition of registered trade union is regulated by the code of discipline, which is the only voluntary and is often breached by the employer. Whether it is true or false? So answer is absolutely true, as per the defined that the international recognized standards, labor standards in India. So this is what, my dear friend, the learning aspects over there. Then if you want to learn something extra, then you may refer these three books also are there. So in today's session, my dear friends, we learn that what are the different aspects of labor, the introduction point, the I.L.O situation, the international recognized standard is in India, then impact of I.L.O, the different legislations over there. So hope you learn well in today's session, my dear friends. Have a great study, have a great day. Thank you.